can hear you okay. Yep.
Thank you, Dan. You're right there. Morning, ladies and gentlemen. My name is Chris Lagado. I'll be chairing the meeting here today. All visitors were signed into visits book. The entrance is to be in the field takes. This includes kitchen staff from other buildings. There are no planned fire evacuation drill or alarm tests today, so if the alarm is activated during the visit, you must exit the building immediately. The council officers will direct you to the nearest fire exit and will escort visitors to the building fire assembly point beside the Silver Man at the top of Parliament Walk. Kilkenny staff should report to their floor's assembly point. You should remain at your assembly point until directed to reoccupy the building, and only be entered once the fire marshal has advised it's safe to do so. Please do not attempt to leave the site by day though, and until cleared to do so by the fire marshal, to ensure access routes are kept clear for emergency vehicles. Please note that this is a public meeting, and members of the public may be in attendance. The meeting will be recorded by the clerk and published online for public viewing. The taking of photographs, including screenshots, audio or video recordings, are not permitted during meetings unless with the express permission of myself. The members attending virtually activate the cameras where possible to enable you to join by video, and can all attendees mute their microphones when not speaking. Please do not come in during items unless I invite you to do so. If members attending virtually wish to speak on any point, please indicate by clicking on the raise your hand button. Members of the chamber should also raise their hand, and I will bring you in at the appropriate time. If members have not been able to access all papers for the meeting, please indicate. I'll now ask the clerk to take the roll call to confirm attendance at the meeting, and ask that members indicate if they wish to declare an interest. Clerk.
Apologies from Councillor Lindsay, Councillor Law, Councillor Keogh, and
Councillor Keogh might join in.
Maybe join
online instruction.
Okay. So Councillor Keogh might join at the stage. Excuse me, can I I've just had a message from Councillor Keogh who says that she's struggling with the link. I wonder, can you resend it? I would see if you can invite her into the meeting. She's emailed me directly.
Sorry, who's doing the link?
Councillor Keogh.
Right, yeah.
She's struggling with the link. Might be easier just to say he's actually present at the moment.
I'm sure Councillor Keogh will be pleased to be called up.
So,
This one? Yeah, he's just coming. That's the one.
can you hear us okay, Councillor Keogh?
Back on it, good.
So I'll just reconfirm that. So apologies from Councillor Clockey, Lindsay, and Councillor Law. Thank you.
We'll move to item 3, which is page 3 of the papers. Page 1, page 2, page 3, and page 4. Is that actually the record of the meeting? Agreed. Good. Well, 4 items of business here this morning. And we'll start with item 4.1, which is the name of the Premier at 53 Harris Court, Norwood. And the legal court. What name was it? Oh.
Good morning, Convener, ladies and gentlemen of the board. Good morning. This is an application for a new premises licence. I have no concerns, no objections to the current licence. It relates to a retail shop that's existed in this location for many years, but it was previously licensed prior to the licence in Scotland Act 2005 in place. The only matter to raise, and I've indicated it's a matter of concern, of course it's not a matter of concern, it's just a matter that requires to be raised in terms of the licensing board's statement of licensing policy, is that at page 19 the board would require premises seeking to make home deliveries of alcohol to have this specified on the operating plan. This approach is specified on the operating plan and as part of the application. The policy goes on to indicate that home delivery of alcohol should be robustly managed by the premises and it is likely to attract additional conditions. Appendix A in my report, I've listed a set of conditions that are proposed are necessary and expedient for the purposes of the licensing objectives and should be added to this licence in the event that the board decides to grant it. I have discussed the likelihood of these conditions with Mr Elmsley. I understand that there's no concerns about any of the conditions that are proposed and that they indicate that they would be able to operate satisfactorily within the terms of those conditions. Happy to answer any questions if there's any.
Thank you. Members, any questions before? No, I see no indication. Mr Elton.
Thank you. Good morning, Lord. So as stated, this is an application for premises licence for Brett 32 Harris School in Alva. I'm representing Mr Harris, who is the Pan, who operates the premises. The background is, as Mr Fair has said, it's previously been a convenience store for 20 years with little investment for the last 25 years. My client to go on earlier on this year has undertaken extensive work to renovate the store into making a modern community store. Part of that challenge was regarding building standards where there was a new standard board that had been resolved from previous operators and mechanics of all that getting that resolved. The unit carries a large range of convenience foods and at least matches the range offered by similar local stores. It does include the offer of alcohol at 18.03 metres square, displayed in two areas, one behind the counter for high value items and a chill display area for meals and wines. The client has installed the latest AI security technology. If you've not seen some of that, that is basically where as you as a customer walk in, cameras profile you identify your age, your picture comes up and it guesses your age as part of that, stores your history and basically manages repeat customers. If a customer then attempts to purchase something that doesn't get presented at the till, it flags up that potentially you have secured a product that's not been paid for. So it's the next stage of kind of state of the art and potentially helps retailers manage potential threats moving forward. Mr Veerpan is an experienced licensed operator. He has previously managed a number of petrol station convenience stores for a large national UK operator over many years, as well as assisting a business associate running a number of convenience stores throughout Scotland. This is his first solo venture. And he has, over this period of time, no issues with any of the sites he's managed from a licence perspective, where he's a strong track record of being a transparent and diligent operator, and he's not caused any issues with compliance. Regarding the home delivery is included as a future proof. We don't intend offering that at this present moment in time. However, we're happy to accept the condition proposed by Mr Fair's part and parcel of it. It is likely he will use the online app of Snappy Shopper as part of that solution, which I'm sure members will be familiar with. No other observations or comments from the Scotland residents or the area, so we'll be happy to propose a move to grant. Happy to take questions on.
Thank you. Members? The members have any questions for Mr Edler? Go on.
Yeah, sorry, thanks, Chair. It was for Paul. I just wanted to double check that the conditions we're putting out for the home delivery, is that the same sets of conditions that we've put out for previous applications of a similar nature?
Very much from the standard conditions that we approved during the work. We're developing the most recent statement licence policy, and are included those conditions and amongst the list that are suggested in the licensing policy that may well be used in this case. I think all of the conditions were relevant and have been suggested. Of course, the board, if they're minded, you can add to that or remove any of the conditions that I've suggested. It's a matter for the board, but yes, identical to those that have been suggested. for the many other recent applications that we've had to include home delivery on the licence.
Okay, thanks, Chair.
Thanks, Chair. Yeah, it's just as saying that the home delivery is not going to be used at the moment. Is that will that need to come back to the board, or will it be assumed that it would be okay if it's being doing just now, but they're not actually going to be doing the home deliveries?
If it's granted today, they would immediately be able to offer home delivery, but there's no obligation to offer home delivery, so they can introduce it at a time in the future when it suits. I expect a regular contact with Mr. Emerson if he became aware that home delivery was about to start. I think certainly he would let me know when I'd be aware.
That's great. Thanks. Yeah.
Thank you. I'd like to just say before we carry on that the licensing board are asked to consider all information before it, and have done so to determine whether to grant the license subject to local conditions, or refuse the application. I had a look at the plan in the shop, and I was highly impressed with the amount of CCTV cameras that are dotted about the place from outside the building and carried on to the inside. I take it these cameras are what we're talking about, the AI detecting.
They are. Where the challenge will come, and it will come from a challenge for Police Scotland and for fiscal, is it's very likely that technology is running faster than their system is to be able to identify. The technology that's in the marketplace nowadays for AI is actually quite scary as to where that kind of stuff will go. I mean, actually, there's a more advanced one now that if a customer picks up something and secretes it on the shop floor, the music stops and an alarm goes off. So basically, it's almost like someone pointing a big finger. That's not going in here, but I've got other clients who are using that technology going forward. So really, they've taken the kind of post-COVID theft level that are going up. The technology is just driving that. Some of that's coming through the stuff that's been done at airports. You go to Heathrow Terminal 5, it's very different nowadays from where it was maybe 5 years ago with technology and how the facial recognition is part of all that kind of stuff. So it's just becoming more and more advanced all the time. So the challenge will come where technology is going to strip in what Police Scotland and fiscal be able to interpret.
Thank you. I see there are no objections from the police, but given the whole talk about the AI, would the police like to comment on that?
Yeah, just to confirm, first of all, good morning, I'm Sergeant David Bellingham from the Licensing Department in Forth Valley Division. Yeah, just to reiterate, there's no objections or representations from Police Scotland in respect of this application, in respect of, in particular, the mention of digital evidence. Actually, Forth Valley Division has just been the second division within Police Scotland to incorporate a new desk system, which is basically digital evidence, which is fully incorporated into the property and fiscal service. So, yeah, we are sometimes a wee bit behind with technology, but in this occasion we are quite well advanced to keep up with, obviously, technology out there in the public domain. So, anything that helps us from a digital point of view is certainly a positive as far as Police Scotland is concerned.
Thank you. Anybody? Comments?
I'm happy to move approval with conditions, Chair.
So that's the grant application subject to conditions.
Yeah. So I move that we approve the licence with the standard conditions in relation to home delivery, although we acknowledge that applicant might not take those up immediately. I'm happy to support. I think these convenience stores are a diminishing resource within the community, but are much valued, and therefore I'm pleased to see that the applicants made this application and is keeping up with the times, and I wish them well in their business. Thanks, Chair.
Yeah, well, I'm actually glad to second this. Actually, it's within my ward as well, so I know the store. I've known it for quite a number of years, back to the previous ward. I'm glad to see, as Donald said, the state is keeping up the technology. Looking forward to other licensed premises taking this technology on. Not only the convenience stores, but it may be all about incremental licensed premises as well. So it's something for the future, something we should be excited about. So I'm definitely glad to second it. Are we all in favour?
Yeah.
Agreed.
Yeah. Thank you, unanimous. Thank you, unanimous.
Thank you very much, Your Honours. Appreciate it.
The next one is an application for Clackmannanshire Road Service Station. And we have Mr. Hunter.
Good morning, Your Honour. Yes, I'm going to Martin Blue. I would normally have an applicant listening, but come here during the course of submissions, the area managers for all the people are currently doing site conversions, and I'll avoid that.
Good morning. This is an application new premises licence for a petrol station in known as Clackmannanshire Road Service Station. It's the former Morrison's supermarket petrol station that was changed hands to an independent operator, and they are now seeking to sell groceries and alcohol from the premises. As I'm certain that the board are aware from their training, the garage or petrol station is known as an excluded premises. Included in the appendix A, the extract from the 2005 Act that explains section 123 describing excluded premises. Section 1235 makes it clear that premises are not excluded premises that persons resident in the locality in which the premises are situated are likely to become reliant to a significant extent on the premises as the principal source of road fuels or groceries. Be interested to know that the sale of alcohol is completely irrelevant at this stage when you're assessing whether a person's birth race is excluded premises or not. But as I've done previously with other applications for petrol stations in this area, I conducted a little bit of research, very non-scientific, as you will see from the information that's contained in paragraph 7. First of all, I made a consideration of what is the extent of locality in which the premises are situated, and are there any residents in that locality, and are any of those persons relying to a significant extent on the premises as a principal source of road fuels, and are any of the persons relying to a significant extent on the premises as a principal source of groceries. So having considered these matters, I concluded that a significant part of the town of Alloa could easily be considered as the locality, in the locality of the applicant premises. And that there are persons definitely resident in that locality. So I acknowledge that the final decision is on what is the locality as a matter very much for the licensing board to determine. But I think in this case it would be quite difficult to argue that significant portions of Alloa are in the immediate locality of this premises. Should the board agree with my conclusion on the locality, then I can confirm that my restricted, limited and very scientific research confirmed that persons resident in that locality were indeed relying on the garage to a significant extent as a principal source of road fuels. I was unable to conclude that any person resident in the locality was relying to any extent on the premises as a principal source of groceries. That's not surprising given the close proximity to 5 major supermarkets in the area. The likelihood of somebody relying on a garage for groceries is pretty small. My research consisted only of 4 separate, relatively short site visits to the premises at different times of the day, including one in the evening. And during these visits, I interviewed individuals who were drawing fuel. I noted the postcode information from those who were purchasing fuel, and just asked them simple questions. relating to their grocery shopping habits and regular fuel purchases. I spoke to a total of 32 people, 10 of which are not resident in the locality and disregarded their input to any further questions. The 22 persons who were resident in the locality, 19 interestingly stated that this was the only garage that they bought fuel from in the last year, and that they were relying on it as the principal source, if not the only source of fuel for their car. The others indicated that they had purchased fuel in other areas, some quite far afield, as an aside. Of the 19, 8 persons stated that they'd never purchased fuel anywhere else in the last 3 years. It was interesting that those 8 persons were very local. They all, the postcodes related to the immediate Hill Park, no, not Hill Park area, is it? Hillcrest area of the town. The other 11 said that they mostly purchased their fuel from this garage but had purchased fuel elsewhere. None of the 32 indicated that they were anyway relying on the premises as a principal source of groceries, citing, of course, the selection of nearby supermarkets. So in conclusion, I agree first of all that the premises should not be considered as excluded premises, and I'm certain Mr Hunter was going to add to that argument with the survey firm that they have completed as well. The only matter of significance connecting this application is the answer question 5F that indicates that the garage would offer home delivery of food and groceries, and alcohol. And as previously explained in the previous hearing, I would simply suggest that a number of conditions may well be necessary and expedient for the purposes of the licensing objectives, and those conditions I think are contained within the appendix. Bear in mind, I hope yes they are. They very much match the suggested conditions of the previous matter. They're just a straight the licensing policy. Those that appear that are part of the board will know that work with forming those conditions and designing those conditions to make them suitable for a wide variety of licensed premises, but make them generic enough that they fit all of the licensed premises and can be easily worked with. I am not certain I had a specific discussion with Mr Hunter about licensed conditions. I'm certain that Mr Hunter, if there was any difficulty with any of those conditions, I'll take an opportunity to read them today, prior to today, and raise any concerns that he's got. I've got nothing further to add unless there's any questions.
Thank you. Before we move to questions, what I should have said earlier was that, again, the licensing board are asked to consider all information before it, and we have done so to determine whether to grant the license with conditions, subject to local conditions, or refuse the application. Are there any questions for Paul?
I'm just trying to put the box the licensing board is further difficult could define a little bit more that's a definition of excluded premises in relation to petrol filling stations and alcohol. Explain that a little bit more.
Excluded premises are contained in page 65.
Usefully I can, but I will have to refer to the appendix that's about the report. The section 123 of the 2005 Act basically says that no premises licence or occasional licence has effect to authorise the sale of alcohol on excluded premises. It offers a definition that excluded premises means any premises on land acquired or appropriated by a special roads authority is not relevant. For the time being, used for the provision of facilities to be used in connection with the use of a special roads authority or for the use of traffic of class 1 with or without other classes. Again, not relevant in this significant in this situation, but section 123 subsection 4 is the relevant part for us today, and it goes on to say that premises for the purposes of subsection 2b, that's where the premises become excluded. They're used as a garage, and if they're used as for one or more of the following purposes: the sale by retail of petrol or derv, the sale of motor vehicles, or the maintenance of motor vehicles. So if they're a petrol station, a car repair garage, or a car sales garage, they become automatically excluded premises unless they meet the exemption. And the exemption, as I explained earlier, is that person's resident in the locality become reliant to a significant extent on the premises as a principal source of petrol or groceries, petrol, diesel fuel, diesel road fuel, or groceries. In this case, I've carried out a bit of research to demonstrate my belief is that there are people resident in the locality, and it could be as little as 2 people, but it's definitely a plural. I think there's other discussions around the matter that say that it has to be more than one person, it has to be persons. In this case, there's definitely more than one person who claimed in a random approach from the council officer to be significant or relying on that location for the sale of fuels. Therefore, in my view, they're no longer excluded premises and then would be entitled to have and hold a premises licence for the sale of alcohol.
Yeah, thanks for explaining that, Paul. That's helpful.
Are there any other questions?
Thanks very much, Convener. I suppose before getting into the substance of the submission, it may sound slightly sycophantic, but can I thank Mr. Fair for the comprehensive report that he submitted. I've been doing applications for premises licences in connection with petrol stations for about, exactly about 19 years. I've never seen a report of this substance. I've never seen a licensing standards officer take it upon him or herself to go out and do some interviews on field. So it's a very comprehensive report. So you're very lucky board to have a report of such substance. I'm grateful for Mr. Fair's assistance in that regard. As far as background to all this is concerned, so Motor Fuel Limited are the UK's largest independent operator of petrol forecourt stations, and independent in this sense means that they're not tied to fuel supply from Esso or BP or so on. So they operate forecourts up and down the country. And what's happened here in the last 6 months or so is they have acquired at a not insignificant cost of £2.5 billion all of Morrison's petrol forecourt premises across mainland UK. Essentially, the Morrisons didn't want them anymore. Motor Fuel have acquired them. There's 49 of the sites in Scotland, which obviously one is in Alloa. And as part of Motor Fuel's trading operation, they operate much more significant convenience stores than you might have experienced if you've ever been into the Morrisons site. Morrisons petrol stations traditionally are very much buy a newspaper, a can of juice when you're getting your fuel. Motor Fuel's model is completely different from that. So although they don't have any in your own board area, they're very much around you, even if you don't perhaps realise that they are. The Earth site just before the two bridges from the south side of the bridge of the river Carn. It's not terrible, you should know that. Before the Carn Bridge and the Clackmannanshire Bridge, on the roundabout there's the Halls of Air site. That's Motor Fuel's site. They've got 3 sites in Stirling, 3 in Falkirk, all of which are licensed. I'm pleased to say, from my perspective, that I've acted for Motor Fuel since 2017, and I've only ever had to appear at licensing boards making applications. So, from an operational point of view, if this licence is granted, I would hope that Mr. Fair would experience that they're able to deal with and have no concerns. This particular site is part of a process whereby all the sites are handing over from Morrisons to Motor Fuel. This particular site is scheduled to close this Sunday coming, 6th of October, and there'll be some renovations done over a 3-day period. All being well, the forecourt shop will reopen. Sorry, the forecourt in terms of fuel sales will reopen on Wednesday, and the shop will reopen either on Thursday or Friday of next week. And when that's completed, if you go along, you'll certainly see a significant difference in terms of the retail proposed. As part of that, as Motor Fuel do across some, before they bought any of the Morrison site, they had 95 sites in Scotland, like all but 2 were licensed. Under the current process we're pursuing, there's been 36 of these style of Morrison's petrol stations have been granted licences. I think there's 9 of them trading, so they've got about 100 licensed premises in Scotland. So they're very experienced, and the alcohol proposal here, the 942 square metres, reflects the kind of size and capacity they generally put in a convenience stores. It's all about having the complement to the existing grocery store rather than trying to create an off-sale style premises. I said I was very grateful to Mr. Fair for doing his own research. I'd also prepared, or I did prepare, you hopefully have on your papers, a market research report from a business called Taylor Mackenzie, who go up and they do a more substantial exercise than what Mr. Fair has done. And I mean that in the sense of, I don't mean this to have a go what he's done. God only knows what people thought when you approached them in court, frankly. So this was a formal market research process, and the style of questions that you have an opportunity to look at it may seem slightly odd, but that's because the statutory test is slightly odd, and the questions that have to be asked all have to follow up a process to get what would regard to be relevant answers to questions. And a similar experience to Mr. Fair, you'll interview some people, they're not local residents, so therefore they don't carry on with the process. You interview others that are local, so they then ask more questions. I'm happy to go through it in detail. Incidentally, is it Councillor? I can't see your name. Well, there's a fuller explanation of their process in the appendix to the market research about locality and the statutory test if you need any further assistance in relation to it. What they did is they interviewed 425 people, and their process is done randomly, in the sense they don't ask everybody to participate. And I suspect that Mr. Fair probably found some people choose not to participate because they don't either want to take up any time or they just think it's not for them. And so the process is random. It's done on a local resident basis, of which the market researchers interviewed will be determined to be 130 local residents, and their postcodes are in the research report. Of that 130, 89 said the premises were their principal source of fuel, and from that number, just under 60% said they would regard themselves as disadvantaged or inconvenienced if the facility wasn't available to them. So that nets down to 51 out of 130 local residents satisfying what I would regard to be the statutory test. That's 39%, and oddly enough, I think it's consistent with Mr. Fair's reporting. When he said 8 out of 19 said they didn't go anywhere else, and it was 42%. So similar, it shows a consistency of reliance. The numbers in the market research are slightly higher, but they're, in my submission, all point to the conclusion that Mr. Fair reached in relation to the excluded premises test, that there is a sufficient body of individuals who rely upon the premises as a source of fuel to take you out with the statutory exclusion. Which is very fairly, Mr. Fair, that's a terrible sentence, but very fairly commented that there wasn't a reliance on groceries, and I think you would expect that, particularly with a site that's not been renovated. If you look at what the Morrison's petrol station looks like now, and it's sitting in a close proximity to the supermarket, you would, I think, you'd have an expectation that people wouldn't go there for their main grocery shop. Motor fuel may change that to some degree for some individuals when the more substantial convenience store is there. We'll have to wait and see, but the fuel reliance in of itself, in my submission, is sufficient to discharge the exclusion. In relation to the proposed delivery conditions, they're all fine apart from two, but not for reasons of us not wanting to comply with them, but difficulties that we may encounter in complying with them. So if I make it clear that motor fuel don't use their own delivery drivers, they utilise the services of Uber Eats and Just Eat if they're trading in the locality. And I do know that Mr. Fair's conditions make reference to third-party suppliers. So the way in which that works means that motor fuel are not directly doing the training of the drivers. It's the organisation that employs the drivers. So Uber Eats and Just Eat are responsible for the training, and they do that in relation to all sites that motor fuel operate on. So it's just in relation to numbers 4 and 5 about the recording and training. I'm more than happy that we I suppose effectively request that information, Mr. Fair, and should be able to access it. But whether we'll actually always get the records of the individuals' drivers at any one time and be able to retain them on site is the difficulty we may have purely on a GDPR, a general data protection regulation basis, because they're not our employees and we would be relying on the third party giving us the information. We can certainly make a point of requesting it, but we wouldn't necessarily always have that, or alternatively, if we get, I suppose just envisaging a situation where the third party gives us a list of the trained drivers, and we have that on site, and then someone else takes up employment with Uber Eats, our records are not updated, they carry out a delivery, Mr. Clear just happens to come in and says, can I see the list, and then the individual's not on it. You know, there's a possibility of an inverted breach of the rules, I suppose. So whether they are deleted or simply left in on the understanding, as I'm explaining, that it's the one where we do our best to comply, that it's not necessarily in our gift to comply with them. What I can give you the assurance about is that the way in which the deliveries of these third parties operate is that only trained drivers are able to pick up alcohol deliveries. You know, what that means is that businesses like Uber Eats and Just Eat operate on a smart technology basis. Stop me if you've heard of this information before. So from the driver's perspective, they will see, a bit like a taxi driver, they'll see a list of jobs coming up on their screen in their car. And if one of them contains alcohol in it, it will be flagged in a certain way. If that driver has been trained, he will have permission to access that delivery to go to the store and collect it. If that driver hasn't, then effectively the way in which the smart technology works is that he could try and offer to collect it, but the system wouldn't let him do it. It would have to be another driver who has completed the relevant training who then collects the job. Hope that makes sense. So, and the backloading of the system before you order it is that it has to be ordered to an address by a person who has an account. They have to have appropriate identification for the purpose of Challenge 25 and so on. So the likes of these delivery companies can't or won't deliver to a location, they only deliver to an address. So whether that may be a business address, if somebody's going on in a business, or a home address, but they couldn't deliver to a park location or something like that, which would be an obvious concern from both licensing and police concern. So that's the background to delivery. Touchwood Motor Fuel have been using these two delivery businesses in all of our sites since just after I was involved in around 2019, and we've not had an occasion to have to explain a concern arising to any licensing board or licensing examiners. Obviously, that's not a means for being complacent, but it appears to work well. And I do notice locally that other businesses such as Asda and Iceland will utilise Uber Eats, or Uber Eats can be used to purchase from them. So you've got the integrity of other national businesses who are not going to stake their reputations on delivery by these businesses unless they are satisfied as well that the protocols are relevant and in place. So that's the background to all. And I say I'm more than happy to discuss anything in relation to the market research, the applicant generally, or the conditions. But otherwise, I'd invite you to grant the application. And thank you for listening to me.
Before we put questions, I've been asking myself. Appendix B, paragraph 6. It talks about delivery to houses where the person may ensure that levels of alcohol not going to persons who are made, who are or appear to be drunk. How would your delivery drivers be able to assess the fact that this person may or may not be drunk?
Well, like any delivery driver, whether they're an employee of the business or whether they're a third party who has had relevant training, you're always going to be relying on them implementing that training by using the Challenge 25 that's inbuilt into the legislation. Absolutely, I confess I would probably have, I've missed the word ensure there, which I think actually would probably, if we were in a legislative or a court setting, that condition would probably get struck out. I think we'd have to be license holders and premises managers will use all reasonable measures to ensure that delivery of alcohol is not done to persons who are drunk, because unless the license manager or the premises license manager is going on every delivery, they can't ensure that doesn't happen. or that, I suppose that would actually require them to go on a delivery. I don't think that's really the intention. I think the legislation would always require that due diligence is undertaken, so reasonable measures. How does a premises manager do that? Will they ensure that people doing staff are in the store are trained, they ensure that drivers are trained. So motor fuel, as with everyone else's arrangements who use Uber Eats and Just Eat for delivery, have agreements in place that requires that those who are doing the delivery are all subject to the statutory training. So that the measure which motor fuel take, like as a take or anybody else take, is that their deliveries are only collected by individuals who have the training, the Challenge 25 and the integration members that we're all familiar with. And it's then, like any operator, the trust has to be in the person who's been trained that they will implement that training at the point of sale. And that's no different from a situation in a shop where the manager goes out to the cash and carry to go and collect something and he leaves a member of trained staff in, that he has to trust that member of staff that somebody comes in if they're under the influence and wants to buy in the shop, that they'll be refused because they'll implement the training.
Members of any other question?
Just trying to reconcile in my head, so you kind of indicated almost the conditions of our home delivery, 4, 5, 6 and 7 are realistically difficult to enforce. You suggested your company has an artificial intelligence methodology in which to deliver, unless the driver had specifically sent it to that delivery address. So that's an additional subtlety that we could probably build in delivery sort of conditions. But so what's that software program called within your company? To go, I'm just trying to think of how that's a licensing work. What's that?
The previous application in reference to AI. No, this one.
I know. You made reference to the fact that when one of the company that you're using for home deliveries, when the delivery driver will only get an order for alcohol and specific training on that. I'm just wondering what computer package that is, so that we, as a licensing board, can be aware of that for future home delivery sort of applications. Because the flip side of that is you've indicated that you feel our conditions are probably unreasonable or unenforceable.
Yeah, so there's probably some different things being covered there. So if I can take the conditions, if you've got them in front of me, I'll just highlight the points I'm making. So all I was saying in relation to 4 and 5 is that we will do our utmost to comply with those, but we're relying on a third party giving us information, because the drivers are not our employees. So in the sense that we can ask for that information in the expectation and hope that it's given, but if it's not, then we would be accidentally in difficulty with there. I think that in relation to 6 and 7, on a reflective reading on it from the question yourself, is I think as a board, you should, and indeed at 8 as well, be careful about words that say ensure, because that is effectively equivalent in legal terms. In my submission, your clerk will give you advice about it. That's effectively placing a guarantee on the operator, and the legislation doesn't require that. The legislation requires effectively due diligence, and all reasonable steps are taken in order to mitigate the risk of anything happening. And when I mentioned about it being unreasonable, I was envisaging myself in a situation where, God forbid something has happened, and that motor fuel are prosecuted for breach of one of the conditions, because it's a criminal offence as well as possible of a licence review. Then I would probably be within my rights to say to a sheriff, well, that condition needs to be struck out because it's going beyond the terms of legislation. So I think if it was enforced by Mr. Fair in a manner in which that be satisfied that an operator was taking all reasonable steps, which I think would be entirely appropriate for doing it. And what I'm saying is that motor fuel as an operator do that because, and they've been doing it across the country for delivery since 2019, by ensuring that, for example, they enter into arrangements with Uber Eats and Just Eat, where they are contractually obliged to have trained drivers, and the motor fuel can access that information and see that delivery drivers are trained, and they are the ones that are listed as ones who can then collect from the premises. In terms of what that software is called, I don't know. I don't know. It'll be proprietary software of Uber Eats, for example, but I have seen, I don't have it with me, but I've seen flow diagrams of what the driver sees on his iPhone or whatever it is he has up in the car, and he'll see that there's a pickup from motor fuel. One of them might have alcohol in it, and one of them might not have alcohol in it. And if he was if he doesn't have training to allow him to deliver alcohol, if he presses on with alcohol in it, it won't allow him to accept the job. If he presses on with only groceries, then it will, and he can go and collect and then go and deliver. So it's for the likes of sort of business like Uber Eats, if you've got it on your phone to do deliveries, there's a customer interface and there's a driver interface that look completely different. And it's the protective measures for all the businesses, so motor fuel and Uber Eats, is that locked into that is that the permissions of the driver who doesn't have training means that he can't access parts of the scheme to allow him to do deliveries. So it's not, so the insurance, I suppose, is that the driver can't get off the starting line to even have the opportunity to go and deliver. So I suppose in that sense, that's how we safeguard where the drivers had the training and is able to collect the delivery and then goes to the door. And then has the opportunity to assess the person who the delivery is going to. We are in no different situation than any other licence holder across the country, whether in a shop or in a delivery situation, employee or third party. You're relying on that individual having their training and utilising it and making a decision to either deliver, because that person is an appropriate person to be delivered to, or to withhold and say, I'm sorry, I'm not delivering to you because you appear to be drunk, and I'm taking the products and I'm returning them to the premises.
Thanks for that insight. As a licensing authority, I think we're like most authorities across the land are starting to mess with home delivery. So we've got some fairly new policies and that side of things. And also the London Shore and the legal term. Paul, do you want to respond to that in any sort of form? Give us just some thoughts on that. I know we're going a little bit off the tangent. I think that it's something we've debated long and weary about home delivery policies.
Actually, Don was going to make Paul back in.
Yes, thanks. I suppose if I look at sort of conditions at a time, so condition 3 says, and you're interested in Mr. Flurry mentioning condition 3, which I think is probably a bit more onerous than 4 and 5 potentially. Condition 3 says premises licence holder, premises managers must ensure that all persons involved in the delivery of alcohol from the premises have received training in the content of the application of the age verification policy to be applied by all those. The premises licence holder is responsible and the only one responsible for ensuring that the age verification policy is in place. The obligation is on them to be satisfied that anybody making deliveries of alcohol on their behalf is trained in that policy. I don't think it's unreasonable to use the word ensure that they must ensure. If they're not satisfied that Uber Eats and Just Eat have trained the drivers in the policy that licence holder wants to apply to their deliveries, then my view is use somebody else if they're not satisfied. I also understand the all reasonable steps, and of course we're bound by licensing standards officers all over Scotland are all ones like ensure and must that appear all over the legislation and conditions. We're also bound by the reasonableness that you suggest, and I would doubt very much that you have experienced here in Scotland an unreasonable approach by licensing standards officers. So we accept that these words appear also accept as national group of licenses, we accept that there's an element of reasonableness in terms of enforcement. I don't think anybody steps beyond. There are other maybe instances where the challenge matters and go beyond what a solicitor on the opposing side may think is reasonable. But these are matters that are sorted out in individual cases. That, of course, decisions come from that change the way licenses operate and change the way solicitors present in the future. In terms of 4 and 5, Mr. Hunter's taken the issue. I understand the issue is taken, but this is the 4 relates to a record of all the persons in relation to which stage verification policy has been delivered. I think that's quite unreasonable that the premises licence holder should have a record of those that are trained to their standards, not to Uber-Eats standards, not to Just Eat standards, because I don't know what Just Eats or Uber-Eats train their drivers. If there was some satisfaction that Just Eats and Uber-Eats use the principles that are contained within the licence and training of staff regulations and apply that level of training and sign off a training record, and that training record requires to be able to be produced anyway while they're working on or in connection with licensed premises. I'm not sure if you agree with that principle, Mr. To save my points going on and off, obviously you will answer. So I think that obligation, I don't think it is unreasonable. I also equally understand Mr. Hunter's position that Uber Eats and GDPR interfere with quite a lot of things we'd like to do smoothly on a regular basis, but I think it's often used as a method to hide behind complying with something that might be straightforward. I'm not suggesting this is happening in this case, but it is often used. I've encountered, I can't tell you that because of GDPR, when actually, quite honestly, people can't tell me that because there's a legal reason for being able to share the information. So I think it's reasonable that the records are kept on the premises. Now, that might just be a list of names. These are the approved list of drivers. I can't imagine Uber Eats having any difficulty sending to this particular premises or to motor fuels in general, saying here's the drivers that are approved to collect alcohol in this area, and we have trained them in accordance with your age verification policy. There's no great issue with personal information, and Uber Eats, in any case, in my view, should be advising the delivery centre, if you like, the premises. Oh, by the way, that guy no longer works for us, so can you remove his name from your list? Or we've employed these 2 new drivers and they're authorised to make sales of alcohol, to make deliveries of alcohol. So that random Joe with his Uber Eats rucksack and his electric scooter can't just arrive and say, I'm here for delivery number 3257, and somebody not paying great attention to the software says, there you go, there's your bag, and off he goes. There should be, I'm sure it's more, I mean that sounds really simple, but it is happening that fake delivery drivers are operating all over the UK and are successfully able to collect parcels in fraudulent schemes. And I'm sure there are measures in place to prevent that. Uber Eats, I expect, is one of the most long-standing random delivery companies that popped up many years ago, and were one of the first. And I'm sure they have measures in place to prevent that happening. But that measure would include, in my view, reasonably, a list of those drivers. I assume the Uber Eats drivers will carry identification that does have on their phone that will show the delivery centre they will pick up a job. There'll be some sort of signature exchange or marking off the job saying it has been collected, or a scan or something. There'll be something that happens. So it's not unreasonable to conclude that the premises could hold a list of the names of those drivers that are authorised to pick up alcohol. And that would include the training, and that meets that condition 4, and likewise. Condition 5, a copy of the training records should be supplied to the delivery agent. I would be surprised if Uber Eats has any difficulty in supplying that information, but I also expect that Uber Eats may well not be very good at keeping up that their side of the bargain. And of course, no reasonable enforcement officer is going to take a great issue. I can't imagine a copy of a training record ever being something, say failure to produce a copy of a training record, ever being something that I, or any episode on its own, and a standalone matter, would bring to a licensing board as a matter for you to consider taking sanctions on. If that was connected to a driver dropping off 5 bottles of Buckfast to a 16-year-old in a play park and not having been appropriately trained and nobody being able to produce training records or provide evidence that that driver was appropriately trained, that would be a different matter. So as a standalone matter, I don't think anybody has any concerns. I can only imagine if I brought that as a standalone matter to this licensing board, the expressions that I would be faced with, let alone the time I would spend on the naughty step, for doing something of that nature. So I don't think there's any great concern. And again, if the board are of mind to change the wording of conditions 4 and 5 to include some sort of make reasonable requests of Uber Eats to provide this information or to confirm that this doesn't do, I don't think I have any concerns about that. My concerns are, as we discussed at the long term, when we were discussing the complications with home delivery, my concerns are that the home delivery is done safely and within the terms of the licensing objectives. I've got no reason to doubt whatsoever that motor fuels have exactly the same principle in their mind. They've got to a great extent to secure this licence. They're certainly not going to take any risks losing it in the future. I'm happy for it. It would cause me no difficulty if the wording of these conditions was changed slightly. I mean, you know, it's very much a matter for the board. I'm not certain that Mr. Hunter's concerns about the way they're worded are terribly well founded in terms of knowing in 17 years, you know, 19 years that you've been around doing this, I've been doing it for 17, that there would be any unreasonable approach by an LSO, and certainly not an LSO in this area. I'm not certain that any board in this area would tolerate an unreasonable approach from an LSO.
Thank you, Paul. Mr. Hunter, would you like to echo?
Very quickly, because you're I've heard a lot here. So if I can take the ensure conditions first, there's no problem with the conditions insofar as motor fuel ensuring to do something they can control. So the ensuring that people are trained, ensuring that the drivers are trained, that's all fine. It's just I think perhaps in a way in which you asked the question, Kavira, maybe caught me slightly, because we can't ensure what a delivery driver does with his or her training when he gets to the front door. We can ensure that they're trained, and if that's the intention, that's absolutely fine. In relation to 4 and 5, it's nothing to do with us not being willing to try and get the information. It's us trying to not be roadblocked by the general data protection regulations and the point that Mr. Fair makes. Number 5 is slightly different because we'd then be asking Uber Eats or Just Eat to give us a training record for the individual for us to then give it to the delivery driver, whereas the delivery driver is effectively their employee or their contractor, and they'd probably be giving it to them directly anyway. It's the fact that that would be a condition of our licence to get something from a third party to then give it back to another third party. Whereas, you follow what I'm coming from? Because if it was their employee, then it would absolutely be our responsibility to give that person the training certificate. Don't get me wrong, I'm sure motor fuel will be more than happy to request all these things, but it's just simply, I highlighted it earlier on, because we're at the mercy of a third party to give us this information. And in terms of the delivery flow that Mr. Fair is talking about, I can only imagine, and I agree with them, that motor fuel will be one of the most expert at this. Sorry, not Uber Eats knows. And what I can tell you is that the fact that you'll have seen it probably if you've been in a place that has these deliveries around the door. The driver comes in and he or she's got a code on a machine and it matches up with a code on the machine that the operator's got, and it all has to marry up before they get the goods, whether that's a McDonald's delivery or whether that's in motor fuel. So there's safeguards all the way through, because bluntly, reputationally, it's not worth it for anybody. Particularly for something like motor fuel, a risk to a licence, if granted here, is not just a risk to a licence here, it's a risk to a licence everywhere in Scotland if there was a finding of unfitness. So they don't take their obligations lightly, and it's simply not worth it for them if the safeguards are not in place. But I'll say no more than that, because I think we've had a well-rounded hearing. Thank you.
Thank you. Paul?
It's just one other thing. I wonder if we've all, and certainly something at first glance maybe misread. Question, condition 5, it talks about a copy of the record, the training record being supplied to the delivery agent and not being held on the premises. I see now more the difficulty for motor fuels ensuring that a copy of a training record that they've not potentially delivered being supplied to a driver or a delivery agent, when it is a matter that's completely within their control. They can ask that the delivery drivers carry a copy of the training record with them, but it would be very difficult for and I accept that was obviously considered in the context of most of the conditions, I suppose, were originally designed and considered in the context where Iceland, for instance, I use it as an example, employed delivery drivers to make the deliveries. So it's a much easier process to ensure that their delivery drivers, as part of their package of paperwork that they carry around with them, includes their training record that Iceland has delivered. So I think having reread that, I think I can accept Mr. Runner's, and I think it makes no difference in terms of what we're trying to secure if even those two conditions are removed and it satisfies everybody, because they change nothing. If an Uber Eats driver leaves a 17-year-old in a park, half a dozen bottles of workgrass, and motor fuels are liable for that in some way, then it's motor fuels that comes before the licence board and not Uber Eats, and it would be motor fuels that would have to show due diligence to make sure that they had everything in place to prevent that having occurred. So the conditions are, I'd be quite happy for those two conditions in this instance to be removed on the basis that they are not using their own delivery drivers, or once where, maybe an amendment that says that the delivery drivers are employed by Motor Fuels Limited, then these two conditions would apply. I don't know if that satisfies Mr. Hunter's position, because then it would be in control of the training records and the standard of training.
If I mean, we're not going to be employing drivers, but I suppose it would meet in the middle, if that's in order to preserve the wording.
Happy for them to be removed or amended. It matters not to me. The principle is the same, that the alcohol has to be delivered safely and within compliance of the legislation.
So you're talking about removing 4 and 5 of the suggested conditions.
It's very much a matter for the board, but I'm suggesting that I have no concerns if the board decided to remove 4 and 5 on the basis of Mr. Hunter's comments on them.
Board members, do you have any questions on this one?
Chair, for me, it's maybe not so much the removal, but the amendment, allowing Paul to amend those conditions to fit more with the operation of the fuel company, I think, is what I'd be after. It does highlight to me, though, that we probably didn't set a review for our home delivery policy at some point. It's new for all of us as licensing authorities, and I don't know, Paul, sorry, have we got a date when to review this particular policy, home delivery policy, or is it only if an incident happens that it triggers that?
The board can review parts of the policy at any time, or introduce supplementary policies at any time. Obviously, the automatic review of the state of licence policy comes after the next local government elections.
If there was no further questions, I was going to move that we approve the application and accept the licensing officer's view in terms of it's not a lease-coded premise, and that we allow him flex, approve in line with our home delivery policies, but allowing them flexibility to alter some of the wording and discussion with the applicant to ensure that they have a degree of enforceability and reasonableness. So I'm hoping that I know not being very specific, but I believe we know the issue that we're talking about in terms of the record keeping. So I'd like to move that. If Paul's happy, he feels he'll be able to find some suitable wording along this line.
Perhaps if I propose that in the brackets after both condition 4 and 5, the words applies only to delivery agents employed by or at the premises.
Is applicant happy with that?
Fine, yeah.
Hello, the clerk and got that then, so it's approval of the applications with the our standard home delivery conditions, but as amended by an agreement with the applicant and all in relation to conditions 4 and 5, is that?
Can you clarify exactly what it is?
Yeah, well, I was getting specific wordings from Paul, so Paul, could you read it? Because again, it was in relation to condition 4 and 5.
The condition 4 would be amended to read a record of all persons trained in relation to the age verification policy will be kept on the premises and made available to the LSO and any constable police Scotland. And this condition applies only to delivery agents employed by or at directly at the premises. And the similar paragraph, the similar wording in brackets after condition number 5.
And so
I'm quite happy with that. In fact, I'm so happy with what you're saying.
Can I hear you?
I'm so happy with that, I'm going to second it. Do we have any other comments on this? Do we all agree to it? Yep. That's important.
Thank you. Thank you, mate. Cheers.
For the next item, we've just got some further evidence. So I think Sean is waiting to print that off for everyone. But as I was exempt, I just want to thank the public for coming and just to clear the room. Was that my